Morning, everyone. My name is Peter Finch. I'm one of the regulatory partners here at Fox Williams. Joined today by Chris Hill, Omar Salem, and Mardi, who kind of make up our payments team alongside me. First of all, thank you for joining. We've only got 30 minutes today and quite a lot to cover. So I will hand over to Mardi shortly to kick us off. Just a bit of housekeeping before we do. We are going to leave some time for questions. If you've got any kind of, as we go through, please place those in the chat function. Should be on the bottom of your screen. Chris will collate those, and we'll try and kind of carve out some time at the end to go through those. If we don't have enough time, we are happy to kind of come back to you on an individual basis and kind of pick up any queries after the session. And I suppose on that basis, I'll hand over to Mardi to kick us off.
Great. So this is just a little bit of context here. So the consultation that's going on at the moment is relevant to all firms that are in scope of the existing safeguarding regime. So payment institutions, e-money institutions, credit unions that are issuing e-money or providing payment services under the payment services regulations or the electronic money regulations, and other firms who voluntarily opt into the safeguarding rules. And as I'm sure you're probably aware, payment firms can choose to safeguard their relevant funds either by segregating them or protecting them through an insurance policy or comparable guarantee. And the FCA says that segregation is used in more than 95% of firms. So the purpose of the regime is to protect customer funds that are received in connection with payment services or issued in exchange for e-money, particularly when a payment institution or an electronic money institution enters into insolvency. I think sort of the key piece of context here is that earlier this year, the HM Treasury issued their review and call for evidence on payment services, including the PSRs and the EMRs. And this review ran from January to April earlier this year. But that was under the Conservative government, and the outcome of this review hasn't yet been published. So notwithstanding this, the FCA have opened their consultation into safeguarding. So what is the rationale for the consultation? Can we do the poll, please? I've got a poll for you this morning, just to check who's had their coffee. Obviously, the most important poll that's happening globally today. So what did the FCA find was the average shortfall for insolvent payment firms. So that's the difference between the funds that were owed to customers and the funds that were actually safeguarded. So I'll just give people a couple of seconds or so to sort of pick their answer. Oh, very close. So we were almost right. 41% of you got the correct answer here. So actually, for firms that became insolvent between 2018 and 2023, there was an average shortfall of 65% in the funds that were owed to clients. The difference between the funds that were owed to clients and the funds that were safeguarded. And this is kind of part of the issue that the FCA has identified, and they've said that there really is an issue, and the current standards of safeguarding by payment and e-money firms is just not good enough. The average first time to distribution for insolvent payment firms was also 2.3 years. So that's quite a long time. And so the FCA wants to make the safeguarding rules stronger and clearer to improve the current standards of safeguarding. Now, a key question here, really, to my mind, is what extent the problem is that firms are just not following the rules properly, or is it that there's a problem with the rules themselves? Now, the FCA's view on this is that there's a problem with both, and that's why they're kind of looking at the rules as well as looking at compliance with the rules. So looking at kind of processes and procedures as well as outcomes, there are some common shortcomings that the FCA has identified in safeguarding at the moment, and those include a lack of documented processes for consistently identifying the funds that need to be safeguarded, inadequate reconciliation procedures to ensure that it's the right amount of money that's being safeguarded, and a lack of due diligence requirements an acknowledgement of segregation from the credit institutions that are actually providing those safeguarding accounts. And I think those are kind of, it's important that the FCA have identified those issues because they feed into some of the changes that Omar is going to kind of talk you through later in the session. So the FCA wants much more detailed requirements. They want to ensure consistency across the industry. And one of the other issues here is the case of IGPAGU. So in PAGU, the Court of Appeal had held that there wouldn't be a statutory trust created over relevant funds when relevant funds are safeguarded. And so when there is a shortfall in an EMI safeguarded asset pool, it should be topped up. Now, that's quite confusing because it creates quite a bit of uncertainty around how this kind of top up should rank against claims of other creditors. So that's also kind of an issue that the FCA is currently considering. Okay, next slide, please. So this is just a very quick overview now. Omar is going to go through some of the key elements of the new regime, but the overarching point here is that the rules will be released in 2 stages. There's going to be interim state rules, and those are focused on improving compliance with the existing requirements that are already in the PSRs and the EMRs. And then there's going to be end state rules, and those end state rules will come into force once we know the outcome of the HMT review and the new relevant legislation is in place. And those end rules, amongst other things, are going to introduce a kind of more CAS-style protection regime. Now, this approach does introduce additional complexity as well as uncertainty because that kind of, we don't know the approach of HMT at the moment, and we don't know the kind of exact kind of new legislation that's going to be in place. The FCA isn't currently able to implement its end state proposals, but it is consulting on both the interim and the end state rules at the moment. So it's important we kind of consider both of them. And then now I'll pass over to Omar for the next slide, please.
Good morning, everyone. I'm going to do a quick canter through the kind of detail of the proposals that the FCA has put forward and try to pull out a few of the key points quickly. Essentially, as Marty said, the rules are divided into interim state rules and end state rules. And the reason for that is that the end state rules require action by the Treasury. And so the FCA isn't able to proceed with them until the Treasury has finalised its review of the payment services regulations. So it's kind of trying to apply a bit of a sticking plaster, basically, to deal with some of the kind of immediate things that it can deal with, but then also trying to also take a broader view of the regime and change it more fundamentally. So as I go through, some of these requirements are going to relate to interim state and some will relate to the end state, and I'll pull out which are which. So the first set of kind of area of action for the FCA is around improved books and records. So that means, on one hand, codifying a lot of the material that's currently in the approach document into rules. And then the other most substantial requirement is a requirement to maintain a resolution pack. And that is kind of a new requirement, and there'll be a requirement to be able to make it available within 48 hours of an insolvency. Next slide, please. Then the other area is around enhanced monitoring and reporting. So there are a number of elements of this. So one is that the FCA wants much more real-time, up-to-date information about safeguarding. So it's proposing a monthly safeguarding return, and it's provided an example of what that return would look like in the CP. Obviously, this would require a bit of a operational build, but the FCA's view is that firms should have all this information anyway, and obviously once they've set themselves up to be able to provide the data, they should be able to do it on an ongoing basis. The kind of more, I think, probably demanding requirement is around annual safeguarding audits, and this really gets to the point that the FCA is concerned about whether firms are safeguarding and segregating correctly. So essentially, they want to have the reassurance of a annual safeguarding audit around that, that could be a substantial cost for firms. It's also at the moment very difficult to actually get auditors who have the expertise to be able to do it. And the FCA is also proposing that the audits would be against an FRC standard, would need to be done by someone who would be eligible to be a statutory auditor. So kind of compliance professionals and so on who may be doing audits currently wouldn't be able to do these audits, which is another kind of, I think, issue because of the lack of supply of audits. And also, I think there are some concerns about the quality of some of the auditing that takes place. The final bit of around they're kind of trying to put more controls around safeguarding is the allocation of oversight for safeguarding compliance to a director or a senior manager. Now, confusingly, this doesn't mean a senior manager in the sense of the SMCR. So it's making the regime like more complicated still because you've got the regime for electronic money directive individuals, and then you've got now put on top of it this additional regime just for safeguarding. So this looks very much like a move towards a more SMCR like approach for payment firms, but it's being done in a bit of an ad hoc way, which it probably isn't the best way of doing it. Next slide, please. One of the other FCA's other major concerns is around third parties. So they're planning to put in a host of requirements around third parties, around making sure that they are managed with due skill, care, and diligence. They are periodically reviewed. There is identification of relevant funds not held in designated safeguarding accounts, and also that firms look at diversifying their use of third parties, although they're still allowing firms to use safeguarding banks outside the UK, so that's still allowed. But there's this kind of point around a higher expectation around control around third parties. Next slide, please. And then another area where the FCA has a lot of concern is around agents and distributors. And we've seen that in kind of some of the action they've taken in terms of limiting permissions and so on in this area. So, they point out there are 24,000 agents, and they're concerned about the onboarding and monitoring of those agents, and also about even if they were onboarded and monitored properly, whether it would even be possible, it would still be very difficult to deal with them on a resolution. So what they're suggesting is that where payment firms have agents and distributors and they use segregation, they will either have to receive the relevant funds directly into the designated safeguarding account or segregate an amount based on historical data of the maximum that would have been held by the agents or distributors from their own funds. So that is, again, a kind of tightening of that regime. And I think that is something to definitely keep an eye on, because it's clear that the FCA has concerns about the agents distributors regime. There's obviously a huge number of firms who are operating under that regime. So I think it's a potential hot topic going forward. And then, as Marty said, the FCA's view is that because of the IPAGU judgment, there is uncertainty about the way that relevant funds are held, and exactly how they would be allocated on an insolvency. I think that is a bit disputed because IPAGU was a Court of Appeal judgment, and ultimately the funds were protected, albeit through this kind of quasi-trust approach of looking for funds within the insolvency. So that is disputed, but I think this is probably somewhere where the FCA has what we would call a kind of real hang-up about this, basically, and they're really focused on this. So I think it's something that isn't going to change in the consultation. and what they basically want to do is put in a statutory trust along the lines of what exists in CAS 7 for client money. I think that this is potentially very complicated, and it's going to be very difficult to work through, and it could actually end up with more uncertainty rather than less uncertainty. If you look back at like previous insolvencies, so for example, the Lehman insolvency, there was a lot of discussion about how CAS 7 interacted with the insolvency rules then. And this is, I think, a bit of a kind of complex, tricky area, and it could actually end up with more uncertainty rather than less uncertainty. But the FCA is, I think, completely determined to go ahead with the statutory trust. So I think part of this consultation, one of the key things will be making sure that the FCA really understands the nuances of the impacts that they could have from introducing the statutory trust, because it's not at all straightforward. Next slide, please. And now on cost-benefit analysis. So the FCA has done a cost-benefit analysis and of the proposals, and they've estimated 150 million pounds of benefits against 106 million pounds of costs over 10 years. This is also, I think, the first cost-benefit analysis that has gone through the FCA's independent cost-benefit analysis panel, which is a kind of independent panel that's supposed to review these analyses and then give a view on whether they are well put together or not. So they made a few comments on the CBA, but essentially they came out saying it was a carefully detailed piece of work that aimed to understand the impact of the policy proposals. Essentially kind of signed it off. Now, I think that they're looking at the CBA, there are actually a lot of areas where the assumptions are quite questionable. So the first is that the FCA makes the assumption that its rules will mean that we go from 65% shortfall to no shortfall, which I think is, very, very optimistic. They also say that they will cut the time to distribution from, on average, from 2.3 years to 1.3 years. And for the lawyers on the call, the FCA anticipates that 4 SEV2 and 1 legal staff will read the legal instrument in large, medium, and small firms, respectively, taking 7 hours each. It's quite unclear exactly how they've calculated the legal costs, but it does seem like quite a drastic underestimate, because it doesn't really take into account that legal function goes beyond reading text. Similarly, on the monthly safeguarding return, they've assumed that firms will not need to collect any further data, which may be correct, and also that it will take one compliance professional 3 hours to complete the return without board and executive sign-off required. My feeling is that having done these returns in practice, there's a lot of kind of toing and froing, especially for the first one, in terms of getting the data right and liaising with other teams internally and so on. And also, I would think that most people would want some kind of sign-off process beyond an individual compliance person, where before data is submitted to the FCA. I certainly, when I was doing data returns when I was in house, would have liked someone else to review it before I put it in, because you obviously want to make sure that it's right and that it's been well considered. Next slide, I think it's back to Marty.
Great. So here are some of the impacts of the proposed changes for the safeguarding regime. And, as Omar's kind of already highlighted, particularly for the second end state stage, the changes are really very significant. The FCA has tried to reflect this in the length of some of its proposed transition periods and in its transitional arrangements, and in its two-stage approach. But there is a question of whether this two-stage approach, which is also exacerbated by the fact that we're still waiting for the outcome of the HMT call for evidence, will result in, much more implementation work for affected firms, because they'll have to kind of, do this in two separate stages. And obviously, we are already consulting on the end stage with kind of possibly not all of the information. And so, will the proposed changes have an impact in the event of insolvency of a firm? Will they actually reduce the time that an administration takes, and the results, result in the fact that consumers will receive their funds a bit more quickly? Obviously, as Omar has already pointed out, it's not that CAS is super straightforward and easy and kind of solves all of the issues with the kind of in the current case law. In fact, that's a sort of very complex situation as well. So are there any other potential solutions that haven't been considered? For example, extension of the financial services compensation scheme. And just on the impact as well, is it fair and efficient for the FCA to consult on the end state rules now, when the legislative amendments haven't yet been finalised? So quite a lot of things to consider there in impact. I've set out some others on this slide, but I'm not going to kind of go through those in detail now, because I want to leave just a little bit of time for questions. So let's flick to the next slide, please. Great. And this is just on practical steps for firms. So there are kind of really significant developments here. You'll need to kind of start thinking about reviewing and updating your procedures, preparing for enhanced monitoring and reporting, things like the resolution pack development, and some of the stuff that Omar mentioned on auditing, and being able to find an auditor that's actually able to offer this service. So there are kind of a lot of steps that firms need to take here. I think the kind of first step, and the step to be thinking about at the moment, is really consider, and if necessary, respond to the consultation. Now, the consultation will close on the 17th of December, so in just over a month's time. And if you do think that any of the proposed rules need clarification or are going to kind of massively impact your business, it's really important to think about that now and to respond. There's 24 questions in the consultation. Some of them are really directly on point for some of the kind of new proposals. But some of them relate to really particular issues like small EMIs, the use of insurance policies for safeguarding and whether those should still be permitted, and characteristics under the Equality Act. So we're really conscious that some firms might only have views on some of the questions, but don't let that kind of put you off considering the consultation. This is something that we're working on, so if you do have questions or areas of concern, then please do just get in touch with us. Next slide, please. So just then, finally, before we move on to the questions, this is just a little timeline that sets out some of the key dates. So you can see kind of first, and in bold, we've got the consultation closure date, which is in December. We're expecting the publication of the final interim state rules in the first half of next year, and then that they will come into force 6 months after that. Now, we know in terms of the end state rules that the FCA is planning that they will come into force 12 months after they're published, but the publication is going to be dependent on HM Treasury's commencement of the revocation of the EMRs and the PSRs, and so particularly because we've had a change of government since the kind of consultation that they ran earlier this year, we don't really know the timeline for those for the end state rules yet. So that is the kind of presentation that we had to go through, and we'll just move on to questions now, please.
Thanks very much, Marty and Omar. So please do put any questions in the chat that may have occurred to you. A couple that we have already. So the first one is around the insurance. So just confirmation of whether the insurance option is still available under the interim rules or the end state rules. And secondly, do you think that that insurance option will become more popular as a result of these rules being implemented in their current form?
The insurance option is still there. I think that it could become more popular if this consultation is used as an opportunity to improve how the insurance option works. So I think a couple of things that people have concerns about are, firstly, whether it can be structured so that it could be used as top-up insurance rather than having to insure, all your relevant funds.
And why do you think it is that so few people use the insurance option now? Is it because of the lack of availability of products, or is it something else?
I think it's probably the structure. So one is the fact that it doesn't really kind of replace your need to safeguard relevant funds, so it's quite expensive to do. And then the second point, which I was just trying to remember, was that I think there's some lack of clarity about exactly how the insurance kicks in on an insolvency. And so that then creates uncertainty, which then puts people off using it, basically.
Yeah, thank you. So we've got a couple of other questions. So one that's come in is, under the current regime, is it mandatory to conduct safeguarding audits for all companies who have safeguarding accounts, even those who are newly incorporated or have limited operations but use safeguarding accounts?
So this is under the current regime.
Yeah.
Well, I mean, one of the key aspects of the current regime is that it doesn't, for example, apply to, well, it can apply to small payment institutions, but small payment institutions are able to voluntarily opt into the safeguarding requirements. But it does apply to small e-money institutions. So it sort of depends on exactly kind of what your authorization status is. But yeah, I mean, if you're a small payment institution, then it doesn't need to apply to you, and that isn't changing. That's this kind of consultation is not changing the scope of who is in and who's out of scope for the rules.
Yeah, thank you. I'm afraid that's all we've got time for. We are up to 10 o'clock. Thank you to Omar and Marty for that presentation. We are here and around if anybody has any particular further questions. Do get in touch. We hope that's been useful and hope you enjoy the rest of your day. Thanks very much.